Hi, I'm Katie Spadoro, and I am here today talking to you about when you should hire HR for your company. This essay is all about that question. By the end of the essay, you'll know when to hire HR for your growing business in order to protect yourself. If you ask me, as an HR professional, I wouldn't start a new company without having HR in place. It's huge. Of course, like I said, I am an HR professional, so I have seen all of the potential pitfalls of not having policies and procedures updated and in place prior to hiring employees. It is much faster and less expensive to put these processes in place before you have an employees versus down the line in a couple years when you have 10. I have experienced working with companies that have 2 employees. I've experienced working with companies that have over 300 employees. Every single time, the owner of the company will say, well, I guess we should have probably done this a few years ago. So I'm going to break this down for you a little bit so you know when you should hire somebody for your growing business. My first response is if you have an employee. If you have 1 employee, you are required to follow laws. The more employees you have, the more laws there are to follow, which is so much fun. For example, if you have any employees, you must adhere to these following laws. The IRCA, which is the Immigration and Reform Act, the EPA, Equal Pay Act, the Employee Polygraph Protection Act, the FLSA, the Fair Labor Standards Act, OSHA, which is the Occupational Safety and Health Act, Employee Retirement Income Security Act, which is known as ERISA, Uniform Service Employment and Reemployment Rights Act, which is known as USERRA, Consumer Credit Protection Act, the CCPA, and the Jury Systems Improvement Act. So that seems simple, right? Each law has its own individual set of requirements that you are required to follow, steps that you are required to take. So we're going to talk about a few right now. The IRCA is the Immigration Reform and Control Act of 1986. That is the law that prohibits employers from hiring and retaining employees who are not authorized to work in the United States. Employers and employees must complete Form I-9 within 3 days of the employee's first day of work. This form must be retained throughout the entire employment and for a period following the employment. Additionally, there are requirements for the employer when verifying this government document. For example, black or blue ink must be used, crossouts are not permitted, etc. Fines of thousands of dollars per incorrect I-9 can be doled out. This is one of the easiest laws to follow, but also one that we see skipped over regularly. An I-9 audit is a great idea. I typically do I-9 audits for my clients regularly. We walk through that hand in hand. We help them with the process, so in the future they're more comfortable overall in handling it themselves in-house. The Fair Labor Standards Act. So let's talk a little further about that. The FLSA establishes minimum wage, overtime, record-keeping, child labor standards for employees. Every employer with employees is subject to the FLSA's minimum wage provision. As an employer, you are required to post and keep posted a notice explaining this act in a clear place of your establishment, such as the break room. This is one of the many posters that must be clearly posted at your company, and they are updated regularly. The next one, let's talk about the Equal Pay Act. So this law ensures that employers provide equal compensation to men and women who perform equal work within the same workplace. This must also be posted. This is something that obviously has been in the news. There's always been a differentiation between what men and women are being paid in the workforce. So that differentiation, we are making an effort to make it less and less. However, it is still there. So as a business owner, you are responsible for figuring out how to make that work within your business. A way you can be sure that you're doing everything you can to comply with this law is be sure that your job descriptions are updated to reflect each and every employee's role in the company. The next step would be to do a salary analysis across your industry, your company size, and the location, the city and the state, and be sure that each employee's salary is equitable. This is something that we regularly do for our clientele. Obviously, making sure that you are paying your employees fairly not only is required by law, but hopefully is something that you want to provide for your employees just because. So you're watching this video or reading this essay and you have 15 employees. What about you? So if you have 15 or more employees, we can add some additional laws for you. The ADA, which is the Americans with Disabilities Act, this prohibits employers from discriminating against qualified individuals with disabilities in all employment practices, such as recruiting, compensation, hiring, firing, job assignments, training, leave, benefits, everything. The next one would be GINA, which is the Genetic Information and Discrimination Act. This prohibits employers discriminating against employees or applicants based on their genetic information, which is pretty interesting. The Pregnancy Discrimination Act, the PDA, prohibits workplace discrimination based on pregnancy, childbirth, or any related medical conditions. Title VII, this is huge. So this prohibits employers from discriminating in the workplace based on race, color, religion, sex, or national origin. This is the big daddy of HR laws and probably deserves its own blog post. It is super important that you are clearly understanding what this law means to you and your business and how it can affect you. Okay, so this is even more fun. What if you have over 20 employees? If you have more than 20 employees, you must now follow the ADEA, which is the Age Discrimination in Employment Act. This prohibits employers from discriminating against employees or applicants who are 40 years or older. Consolidated Omnibus Budget Reconciliation Act, which is COBRA. This requires employer-sponsored group health plans to offer continuation coverage to eligible employees and their dependents when coverage would otherwise be lost due to certain events, for example, termination of employment. Once you hit 50 employees, there's additional laws. So the FMLA, which is the Family and Medical Leave Act, this requires employers to provide eligible employees with unpaid job-protected leave for a specified family and medical reason. Something that many people do not know, however, is that it is the employer's responsibility to let an employee know that they may be eligible for FMLA. So let me repeat that. It is the employer's responsibility, not the employee's. We highly recommend and we regularly train our clients on this process and how to recognize it. If an employee may be eligible for FMLA, there is required paperwork and a timeline associated that you need to follow. The ACA, which is the Affordable Care Act, this is the employer shared plan. If you have 100 or more employees, again, more laws. So WARN, which is the Worker Adjustment and Retraining Notification Act, this means that employers are required to provide 60-day advance notice to employees of imminent covered plant closings and covered mass layoffs. And then in addition, you're also now doing EEO-1 reporting, which is the requirement to submit employment data categorized by race, ethnic, city, gender, job category, wages, and hours to the EEOC. I could definitely spend all day walking through each of these laws even further, and I will definitely do that in some future blog posts. However, I think that you probably get the idea. Overall, and bottom line, there are a ton of legal requirements that as a business owner, you are required to follow. Being naive of these laws does not reflect well in court. You are a business owner and you are responsible for knowing any and all requirements when it comes to your employees. How can you protect your company in regard to these laws and all of the other laws? Be prepared. You will know that it is time to hire HR in your business when you are getting ready to hire employees. This does not necessarily mean you need to hire a full-time in-house HR employee or a department, but it is pertinent to the success of your continued business that you have someone on hand who has studied HR and employment law and is able to provide you with the knowledge as it relates to your business. The good news, there are companies such as Cyber and other companies out there that specialize in getting you and your business to that next level without having to hire an in-house HR. These options give you the ability to continue to grow and to sleep better at night knowing that your bases are covered and that you're providing your employees with the best, safest workplace where they could be. So isn't that the goal? Like and subscribe to us on YouTube for future HR management tips for your business, and send us a message and let us know what you think. Let us know if you have any specific questions. We would love to hear from you.